meeting of the California Board of Psychology to order. Good morning, everybody. Could we have a call of the roll?
Absolutely. Test. Akwebadu.
Here.
Bernal.
Here.
Kasuga.
Here.
Erickson.
Here.
Fu.
Here.
Horn.
Here.
Jones.
Present.
Phillips.
Here. I would also remind board members that when they speak, they should turn their microphone on. So welcome to the California Board of Psychology meeting. The Board of Psychology has a mission which I will now relate to you. The Board of Psychology advances quality psychological services for Californians by ensuring legal and ethical practice, or ethical and legal practice, and supporting the evolution of the profession. It's nice to see so many visitors at our meeting today. We appreciate you being here. Before we proceed any further, we have a bit of business to take care of, and that is that we've had a new board member join us, and that's Dr. Cheryl Kasuga, and I am now going to swear Dr. Kasuga into the board. Come on up. Or should we do it over there? Okay. Okay. Could you please repeat after me? I, Cheryl Magante Kasuga Saidi,
I, Cheryl Magante Kasuga Saidi,
do solemnly swear or affirm
do solemnly swear and affirm
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies,
against all enemies,
foreign and domestic,
foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California.
And I take this obligation freely,
And I take this obligation freely,
without any mental reservation or purpose of evasion,
without mental reservation or purpose of evasion.
and that I will well and faithfully
And I will well and faithfully
discharge the duties
discharge the duties
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations.
Thank you.
Oh, it's your seat. Okay, the first agenda item today is the public comment for items not on the agenda. For the purpose of the public and also as a reminder to board members, the board may not discuss or take action on any matter raised during the public comment section except to decide whether to place the matter on the agenda of a future meeting. And with that in mind, are there any public comment for items not on the agenda? Yeah. Is he here? Okay.
First of all, just to start off, I have to tell you that my mother and my two aunts graduated in the 30s from the college that's just a few blocks away. So my siblings and myself all graduated from this college a few blocks away. But on the way over here today, I said, now where is Durant Street again? So it's sort of interesting to be back here. At one stage, because I think a few of you know me now, at one stage I went through 26 school districts in my county and got them to adopt a suicide prevention policy. But each time I went to those school districts, one after the next, I barely got there by the skin of my teeth because I live in a large county and some of these districts are hard to find. And I only bring that up because I'm happy I made it here. But my good friend Gordon Dowdy from the American Foundation for Suicide Prevention decided to stop and go back home when he got caught in a huge traffic jam to try and get here. So I'm here to probably do the obvious for some of you, to thank all of you who not only supported but sponsored AB 89, which we're very grateful that the governor signed into law on September 1st. And I don't think that law would have been signed into law if we didn't have the sponsorship of this board. And a number of us up and down the state who work in suicide prevention are very grateful both to the board members that supported that legislation and the administration, which has been just highly cooperative and very helpful. I had in 2014, when we were trying to round up statewide agencies to support legislation to have this type of training, there was an agency that didn't do that for a variety of reasons, and they did this time. And the reason that they told me was they asked me, they said, how did you get the Board of Psychology to support this bill? And I said, I didn't. I just think that good people, after reflecting on what I think is important legislation, just operated on your own to make sure that this bill was in. I just want to comment briefly on training. And I'll tell you the interesting thing is the other day, because of some work I do in my county that involves suicides in our jail system, that a while back there was a contract put out, and a fella, maybe some of you know his name, Lindsay Hayes, who's considered one of the national experts, probably is considered the national expert on suicide in jails and prisons, wrote a report that provided 7 recommendations about what could be done to help prevent inmate deaths. And the first recommendation he gave was that both the clinical staff and the correctional officers needed training, 8 hours of training. So some people I know have objected to this bill and the training, but it comes up time and time again. And for instance, in my county, those individuals who get certified to do involuntary detention, not the law officers because they get a different training, but the clinical folks are required to take a training class, and it's about 6 hours in our county. So the whole thing is starting to align a little bit, and we're very grateful. Just quickly on the training piece, I hope this board or administration takes a look at some of the courses out there or what's being offered. Why do I bring that up? Because several people have already emailed me and said, several professionals, and said, hey, we're putting a training class together, or we want to have a class that's certified. And I think it's important we take a look at that. To be honest with you, my hope has always been, we know from the survey that you did, certain colleges provide training, but my hope is we'll get better and more robust trainings, that this opens up the gate to allow people, and so that we'll just get better and better at what we're doing. There's a rumor, I haven't checked on it, that the first state that passed this type of legislation, Washington, is now seeing different people bring forth new training classes to see if they can get them as part of the certification process. So that's my hope here in California, that we have the same. The next step for us, because for us it's a piece in a puzzle. We're trying to fill in certain areas, and training's one of the important ones, as is community awareness. But the next step is see if we can get the other clinicians, the ones under the Board of Behavioral Science, to also have this type of training. You have a bill, it looks like, on your agenda today, AB 1340. A message went out about that early this week, because that bill just got to the governor's desk, and it's to provide not necessarily suicide prevention, but we hope it'll be inclusive in there, but it's to provide basically primary care providers with training on mental health. The reason being, as all of you probably know, the shortage that we have these days, which is exacerbated in an area like mine, where particular institutions paying more and hiring away clinical staff, and it's putting the pressure on a lot of the other agencies. So my last comment will be this. I'm gonna get up and leave, not out of disrespect for anybody here, But there's another interesting thing I think that started, it's probably been going on for the last couple of months, and that is various groups in this state, including one right now, are holding, maybe we'll call them interview sessions. They're having discussions with gubernatorial candidates. In those discussions, I mean, there are various groups doing various things, but there are a number of groups that are focusing in on talking about governors' awareness about mental health matters and how important it is. I mean, in the end, it's not passing bills or doing a lot of the other actions that people like myself and others do. In the end, I think we're trying to change our culture. We're trying to change a mindset and normalize talking about mental health and suicide prevention and getting people to be more open and receptive about treatment and taking care of what's going on with them. So I'm going to get up and leave, but as a parting note, I just want to thank all of you again. A number of you were very forthcoming in talking about this legislation, and we're grateful to you. Thank you.
Thank you, Mr. Ochakian.
Good morning. My name is Eva Bernard, and I come from Marin County as well. And I would like to ask a board, apparently it's possibility to have a meaningful oversight of PhD psychologists in California. Reason for me asking that, and I got that from your website. I'm very passionate about family court in California are broken. It doesn't take an expert. All you need to do is get on the internet. I will not talk about it, but a big part of it is custody evaluations. And it's been written in the books. For example, that psychologists are becoming advocate for a paying client as opposed to being independent and neutral voice of scientific expertise, which constitutes violation of a discipline's code of ethics, whether a mental health professional is serving. I'm sorry?
I just want to make sure that you're not going to mention any names of psychologists against whom you think there should be some action kind of brought.
I believe there should be some type of an oversight. However,
I'm just asking you that you don't mention any specific licensee names.
I'm not mentioning
Okay,
names.
thank
No.
Thank you.
For sure, I promise. That's from a book. Essential Role of a Mental Health Consultant in Parental Orientation Cases. So that's printed, but it just fits exactly what I'm asking for. However, I'm concerned about creating oversight, and now I'll be omitting a name. In Marin County, most evaluations are necessary. One Marin County woman said long ago that Dr. blah, blah, blah mentioned she would continue to see a couple's child. Also, there was nothing wrong with the child. When mother attempted to report Dr. So-and-so to an ethics board, it was discovered that she sat on a board. So it got nowhere. Okay, here also I have concluding. This one is from Working with Alienated Children and Families, Clinical Guidebook. It's published in a clinical guidebook. Valid collateral source information is critical to ENSO evaluation. In utilizing collateral sources, evaluators will seek information that will facilitate the confirmation or disconfirmation of hypotheses under consideration. However, information from people who have direct observation notice of a parent and child in different situations may be among the most important data. And then it skips and it talks that quite often evaluator want to please a judge to get more assignments from a judge. And I know of several cases when it strongly applies. And I'm just hoping and pleading to you guys if there could be some oversight to those custody evaluation. They vary from 10,000 to 30,000. In most cases, they are not necessary, and they are badged. And if needed, in privacy, I'll testify. I provide all the documentation with proof where testimonies were twisted, data was abused. Evaluator visits a client. There is a divorce, custody. One parent is represented by an attorney. Second parent represents it. I don't want it itself, so I don't say her and his. Evaluator meets with a self-represented parent, and straightforward. You know you're at a disadvantage being self-represented. First, I didn't get it, what that meant, but what it meant, well, I'm gonna work with the other side because there is a lawyer involved who will send me more business. You're not gonna send me any business. I mean, that's so unethical. It's just like, I can't believe it. It became a business. Instead of helping families, instead of helping children, they look what's in it for me. There is a big report, Weightier Matter, and it says verdict on child custody evaluations. Researchers explain why they are fraud. There are some amazing therapists, just like in any business. I'm a realtor, and I know some people should never sell house or buy house for people because they're just not ethical. So each profession has a great people and not. But here we're talking about the lives of the children. And it says most outrageous and truly heinous crimes were uncovered in our litigation and research are those committed by forensic child custody evaluators. So, you know, and there is ton and ton, all from the internet. Nothing comes from my opinion. So if there is a way for an oversight, I would appreciate if the board would consider. But like from here, family trying to
Ma'am, do you want
report.
to summarize your comments so that we need to move on to other business?
Okay, thank you.
Thank you so much. Is there any further public comment?
Catherine Campbell with California Protective Parents Association. Thank you so much for having us during public comment. I will be speaking with Ms. Monterrubio when she speaks about enforcement. But right now I'd like to speak regarding the issues with the ACE study that we know of from Kaiser Permanente and the CDC. We are all hearing how suicide rates are going up, and we certainly know one of the reasons they go up is because of these ACE scores. The ACE study was shown that adverse childhood experiences increase suicide rates, children who cannot complete school, teenage pregnancies, drug use, alcohol abuse. I'm sure you're all aware of the ACE study. What we're not seeing is how our board can work with the ACE study more to prevent this. We certainly know when a family recognizes the problems that are happening within their own walls, they can seek help, and these are being dismissed. What we're seeing in the ACE study is important, and yet when we bring it to someone's attention, we're not ready to hear it yet. Nadine Burke-Harris with the Center for Youth Wellness has designed an intake form that should be used at every physician, every pediatrician's office. And I think that's something the board should look at and recommend that pediatricians do take an evaluation, that they do ask for what these children's ACE scores are. Suicide is preventable if we take care of a child. When we dismiss abuse to a child, the child is more likely to try to get through. We know that children are resilient. But if we leave them in the trauma, they are not healing. And when we are not, as adults, as boards, as professionals, willing to look at the problems as they truly are, we're going to have our suicide rate increase. And we're going to have crimes increase. So I'm asking that this board consider recommending that all pediatricians and maybe even all schools are looking into this. We know that California has agreed to the Aaron's Law that has age-appropriate education on abuse. And why are we not asking the children when they come into school, what's happening in your home right now? It's easy to ask a child, why aren't you doing your homework? And just go do it. We're not asking enough what's blocking you from doing that? We have the resources to do the right thing. And so I'm asking that this board take into consideration and add this maybe as an agenda item, that we can discuss how the ACEs can be further implemented into caring for our children. Thank you.
Thank you, Ms. Campbell.
Good morning, Board and Mr. President. My name is Kathleen Russell. I'm the Executive Director of the Center for Judicial Excellence. Good to see you all. I do have some comments that I will share during the enforcement report, but I did just want to ask, because I did a little homework before today's meeting and looked at our video from the last meeting. And I know that a lot of requests were made by the board of the enforcement manager around some of the data that was presented, particularly the 31% spike in complaints this year. And I know that she committed at the last meeting to break that out in a couple specific ways. And I don't see that reflected in her report to the board today. So I don't know if that was just for lack of time and you're going to be dealing with it at the next meeting. But I do, continue to have concerns, particularly about at least one licensee that I know where there are multiple complaints that have dragged on for more than 2 years. And I know that there's a timeline here for what the average complaint time is for all complaints that come before this board and that are investigated. But I really am concerned that there is at least one individual harming multiple children in the state and waiting for some sort of enforcement and discipline from this body. And it's been over 2 years. And these were complaints written by attorneys dealing specifically with departures from the code of ethics and departures from standards of practice. So we're just sort of scratching our head here wondering, what does it take to get these expedited? And there wasn't really a discussion at the last meeting, which we do appreciate the agenda item last time in Ontario, where there was considerable time spent discussing your new process for dealing with child custody specific complaints. But we remain concerned about particular individuals who even have a history with this board and are continuing to harm the public. And I did, look and see that your number one mission as a board is to protect Californians from psychologists that are harming them. And I've looked at the ethics code and seen there's probably 7 or 8 different ways in which these psychologists are departing from the standards of practice. So hopefully we can talk about that later today. And I did make a request at the last meeting, and I don't see it reflected on the agenda, to ask this body if they would consider making a rule or pushing forward a rule to expedite complaints that are dealing with the health and safety of children. Because obviously if a child is 8 years old and in an abusive home and there's a psychologist that is responsible for that and they're a pending outcome of your investigation. 8 years old, 9 years old, 10 years old, 11 years old. These are really important years of a child's life. And so I just ask the board to reconsider or consider putting that on your agenda at a future meeting. Thank you.
Thank you. Any further public comment? Seeing none, we're going to move on to, go ahead.
And President Phillips, I don't want to comment because I know we can't, but I just want to ask for perhaps a process in the future that we start off and we tell people the amount of time, because I don't want some people to feel as though they were cut short and had to summarize. So I think we should probably, for this section, because we've had a lot more comments where people have been talking about things not on the agenda, we might need to want to set a standard so that everyone feels that it's been fair, because we are hearing everyone's comment, but we know we cannot respond to everyone.
Thank you. Item number 4 is the board meeting minutes of August 9, 2017. Oh, and just to add to the record a little bit, there have been written comments submitted to us in reference to some of the issues that have been raised. We're not going to read those comments aloud, but they will be shared with all board members. Does anyone on the board have comments relative to the minutes? Ms. Jones?
Yes, I have a few comments I'm taking in the spirit of Dr. Horn. On page 1, on line 21, Mr. Fu, I think that's the wrong zip code for your office. I think it's 90071, or is it 17 or 12?
Wow.
Everything in downtown, so that zip code needs to be updated for where we had where we were set at our meeting. On the Southern California Grant Makers, line 21 should be 90012. The other item I had was on page 5, and it would be line 213. And I don't want to misquote you, Mr. Fu, but I feel like a sentence should be inserted, something along this line. Mr. Fu reminded the board the nature of a resolution is to highlight a specific matter. And then the last item I have is on page 7, on page 280, line number 282, in reference to Dr. Jolinder Crow's comment about follow-up for staff regarding the licensed vacancies. I think it was important because I think what she said was, and she expressed concern that the board is missing the license perspective. And that's all I have.
Any discussion of those particular suggestions? Any other suggestions for amendments to the minutes? Dr. Horn?
So I move that we accept the minutes as amended.
So we had a motion, and it was seconded by Ms. Equebadu. Is there any discussion on the board? Is there any public comment on the minutes or the motion on the floor? Seeing none, Mr. Glass-Steagall, will you please call the roll?
Absolutely. Equebadu? Aye. Bernal?
Aye.
Kasuga? Aye. Erickson?
Aye.
Fu? Aye. Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Motion passes.
So the next agenda item is number 5, the budget report, and back to Mr. Glass-Steagall.
Thank you very much. Good morning, board members. In your binder is agenda item 5, which is the budget report. The Board of Psychology has a budget of $4,979,000 in the governor's budget for fiscal year 2017-2018. Attached behind this memo is 4 different attachments. It's the budget report, the explanation of discretionary and non-discretionary budget items, the analysis of the fund condition, and the psychology fund balance and expenditure comparison sheets. I'm available for any questions regarding the materials provided.
So I did have a question, Mr. Glassweigel, and I think that it's been this way before, I've never noticed it. Because we're in 17, 18, why is that column missing? Because in terms of the projected piece, and I was just curious, because I know that you've, through your conversations and other folks presenting to us, when the fund balance changes, and it looks like it was a huge change between 15, 16, and 16, 17. So I was just wondering what was happening for 17, 18. That was really particularly why I was like, that column seems to be missing.
Which page are you looking at?
I'm sorry, page 1 of 4, the fund balance comparison. Because it went from negative 532 to a negative 1.5. I think I'm looking at that correctly.
This one, right here?
Page 1 of 4?
Is it?
Yes.
I'm not sure if I'm in the same order as. Oh, thank you.
Page 1 of
Okay.
4, yeah.
So,
Thank
and
you.
can you repeat your question of the specific area you're
So
looking
the
at?
question is that, on that, the third row, the
Mhm.
projected fund balance from 2015 to 16, from 15, 16 to 16, 17, the projected fund balance is a big change. So then I was just curious what was happening with 17, 18, and what I recall is talking about at some point, you know, the fund balance will drop. I was just curious in terms of, since we're in the 17, 18 year, what is this looking like in terms of the projection?
Okay, thank you very much. This handout is just a projected revenue. And so if we brought in the projected money that we're saying we would bring in every year, and if we spent our entire budget, then our fund balance would be the green line as shown. That's not a true representation of how the board is operating fiscally, because generally every year we bring in more money than we anticipate and we spend less money than we are budgeted to spend. So this is just an example to show if those numbers were, if we spent everything we said we were going to spend, and if we brought in the amount we were going to bring, that we said we were going to bring in only, that our fund condition by this point, we would have negative dollars in our fund condition, which isn't true. And I believe the reason 1718 isn't shown is because our budget analyst, the whole department is switching over to a fiscal system, and it's been a very long process. And so getting the numbers put together have been difficult. So I asked him for the 1718 numbers, and he asked if we could just stay with the end of the year 1617 numbers, because he hadn't received any of the fiscal numbers from fiscal for 1718 at this point. Did I
Thank
answer
you.
your question?
Yeah, that really is, I was just tracking that number, and I understand that
Absolutely.
explanation. I was like, oh, but that makes sense with the fiscal transition. Thank you.
Absolutely.
I'm actually wondering, and maybe this is just a standardized part of the report that our budget analyst provides to us. I don't know that this is really a useful chart, because it's all based on supposition, and we have actual numbers for all the years up to 17, 18. So my thought would be, I wonder if we really need the chart, but perhaps other people find it useful.
No, I actually agree. I was thinking the exact same thing as he was explaining this. I don't think it really serves any purpose.
I see you nodding your head, Mr. Glassweigel.
I agree. They were created some years back and continued just as just to continue it. And if the board thinks they serve a limited purpose at this point, we'd be happy to reevaluate the necessity of the graphs.
It would be appreciated if you could look at that with a budget analyst. Maybe there's a specific reason he wants to include that in our report. Maybe he can explain it to us next time he's able to join us at a board meeting?
We asked him to create these documents specifically
Oh, so it's
before
not-
my arrival here, and so he would be happy to not have to maintain these.
Well,
Anymore.
it's not all the bar graphs we're
Right.
talking about. We're
Sure.
just talking about the first one.
Sure.
Maybe
Yeah.
it would be helpful if we actually said what we would like to see, because it sounds like the budget analyst will create whatever we want to see.
He
So
will.
what is important for us to see so that we know that,
Yeah. Yeah.
Can I add a comment to that? Sure. Also, if you could ask the budget analyst if there's anything he thinks we would benefit from seeing that we are not seeing at this point, that could also be helpful.
To pile on. A brief narrative perhaps when the graphs are shown so that we are contextualizing what we're looking at, because I think without 2 lines of a brief explanation of why we're being shown this, it might be helpful for us and the public to understand the general narrative that is being presented about these numbers.
Sure.
It would be easier to read the reports, I think, because unless you can really hone in on the data, it's not always entirely clear why I'm reading particular data.
And as you're asking those questions, Mr. Glass-Steagall, perhaps as a question too to the analyst to ask about frequency, and maybe it doesn't need to be on every board meeting. I feel like when I first joined the board, part of the conversation and part of the presentation of the analyst at the time was to talk about the, to be able to respond to licensees about fees and costs, and to show in terms to explain the efficiency in terms of funding. But I don't know if, like for instance, if there's, with the new system, if they're getting data at a certain frequency, maybe it isn't every board meeting, and he could give us some direction on that.
Sure.
Any further comments or questions regarding the budget report?
one of the things I think that we had wanted to know that we kept tracking for a while was when are we going to get back the loan? When are we going to get to a place where we're going to get that loan back? And I mean, if, as I'm looking at this, it looks like we're never going to get it back because we in fact aren't spending, you know, and if that's the case, or we are going to get it back on a date certain or something like that, I mean, that's a different issue. It's not what we want to see all the time, but I know that's one reason we're looking at this. When can we expect this to come back? So
I can speak on that if
Okay.
you'd like. So the analysis of the fund condition, handout number 2 after the, it's the first one after, or the second one after the 4 pages. Our months in reserve from, it starts at 16, 17, and then 17, 18, 18, 19, 19, 20. Right now, they have the loans scheduled to be paid back in 19, 20. The reason they're at that point is because at the end of 18, 19, they are expecting the board to have 3.3 months in reserve in our fund. Anytime a fund is between 3 and 6 months, that's considered a healthy fund. If you have below 3 months, that's when it would be necessary to discuss a fee increase. But we wouldn't discuss that because we have these outstanding loans. So that would trigger the loans to be repaid with interest. And then that would set us up for what they expect to be, and this is calculated without interest, but 13.4 months in reserve. Now, again, if you're over 6 months in reserve, they have you discuss a fee decrease generally, but we have the benefit of being able to show them that we do operate at an imbalance, so we do spend more money every year than we bring in. And so that's why, if you look at the months in reserve in the analysis of our fund condition, we've gone from 9.8 to 6.6, and then, assuming we go down to 3.3. So we will dip into that 13.4 months and draw it out as far as we can. And then at that point, once we get around the 3 months and below, we would then reevaluate the necessity of our, the amount of our fees and see if we need to have a fee increase at that point.
Is that to say the entire loan, I've forgotten how much it is, would be repaid in 2020, or only enough to reach 13.4 months?
It's a good question. I would assume that they would put back both loans at one time, but I assume they could always make the decision to put back just one loan. To get us to 13.4, they have calculated putting in both loans. It's like 6.3 million, I think. And that would also come, any loan that they pay back comes with interest. So we would be well over the 13.4 months calculated because we don't have the interest dollars. But I assume they could always put back just one, either the 3.8 million or the 2.5 million with interest and kick us back up a little bit versus the full amount. It would be whatever Department of Finance decides to do at that point.
Further questions or comments from board members? Is there any public comment? Thank you very much, Mr. Glassspiegel.
Thank you.
The next item on our agenda is the enforcement report. Good morning, Ms. Monterrubio.
Morning. And the enforcement report is item number 6, and it starts off with my memo, followed by the overview of enforcement activity, and then the enforcement performance measures. Since July 1st, the board has received 164 complaints. All complaints received are open and assigned within 7 days of receipt. Since July, we've issued 11 enforcement citations, and those are typically issued for minor violations such as having an expired license, advertising violations. Since July, we've referred 7 cases over to the Office of the Attorney General for formal discipline. And we currently have 52 probationers, and of those 52, 5 are out of compliance. We did send out an email blast last month for recruitment of experts. We sent that to over 13,000 licensees, and we received 179 applications back. So enforcement staff is currently looking at those applications. We do have a training scheduled for November 3rd in Los Angeles for our experts, so we're excited with the feedback that we've received, the interest, and hopefully we'll have a pretty good turnout. Currently, we have about 40 experts in the program. We're looking to hopefully have about 100 in the program at one time. So we're excited again with the interest that we received. In order to be an expert, you have to possess a California psychology license in good standing. You have to have forensic experience and be willing to testify in case proceedings. I'm sorry, if a case proceeds to a hearing. You have to have 3 or more years of expertise in specific areas of practice, have no criminal convictions, including any that were expunged or dismissed, and have no prior or current charges of formal disciplinary actions related to any healing arts license, registration, certificate, or credentials to practice psychology or any other profession or occupation in any state in the United States. As most of you know, the experts help board staff with our investigations. They review our cases, determine whether or not there's been a departure from the standard of care. We currently are paying $100 for consultation, so they'll look at the initial evidence and let board staff know whether or not we need to proceed with formal investigation or if the case can be closed. If they are asked to do a final review, that is, we pay $150 for that, and we pay $200 for testimony at a hearing. So again, we're very excited with the interest that we've received, and hopefully the training in November will be great. Any questions about my memo? Sure.
At some point, I'd like us to maybe discuss this, and I'm not sure exactly where this would go, but I'm looking at the criteria for the expert witness, and I see however, at least 40 hours must be in direct patient care. And while I think the vast majority of psychologists, I know the vast majority of psychologists in this state are clinical psychologists.
Mm-hmm.
They see patients. We do have a healthy number who don't see patients at all, but do other kinds of practice. And by the way, we have a general license, so it's for people who are licensed in all kinds of settings other than patient care. And I think we need to broaden that, because how would we rightfully look at a complaint that came against a psychologist who's operating in an organizational setting and doing evaluations to see if people ought to be in a certain kind of job or things like this. So I think this is, obviously we can't do anything about it right now, but I think it's something we would want to look at.
I think that's a great idea. The application to be an expert is posted online. It's on the website. But what I can do is, if we have time at our enforcement committee meeting next month, we can have the committee take a look at the application, make some recommended changes to the board in November.
Great, thank you.
It may be as simple as just saying 40 hours of delivery of psychological services.
Yeah, direct service,
Right.
delivery, but yeah,
Yeah.
that would be totally fine.
Ms. Monterrubio, thank you for your report. And actually, that's exciting to hear you had 179 responses. And so one of my questions I had, and you said there's currently 40 experts and you want to get to 100. It sounds like at some point there might be a need to have like a term to be able to rotate other people in, or is that the plan? Because I know that once you get interest, I know we don't want to stymie that interest in any way. And we want to make sure that if 100's our magic number, and that would be over 200 at this point with those current and interest. How are you thinking about managing that, or you're just probably still thinking about it right now?
I
guess?
am, and they're on a 2-year contract, so they can choose to renew at the end of the 2 years. Again, if a complaint comes in against one of our experts, we take them off of our list. So there's not always going to be maybe 100 experts that we're able to use, but we definitely are looking for neuropsychology, forensics. So I'd rather have more than not enough, of course.
I think that's helpful about the 2 years. Thank
Yes.
you.
Further comments and questions as to the memo? I understand, Ms. Monterrubio, you'll be providing us with additional information beyond the memo.
Just included again is the overview of enforcement activity that I provide at every board meeting, and then we have the performance measures. So if there's questions pertaining to any of those 3 documents.
And I think there were some specific data points that the board members had asked for last time we'd met, so.
Yes, I was actually asked to provide, based on the number of complaints I received for last fiscal year, how many of those complaints were against the same psychologist. And I did pull that information. So we had 1,081 complaints last year, and that's on the enforcement overview. We received 1,042 complaints, and then 39 criminal conviction reports received, which are complaints as well. And there were 21 licensees that had anywhere from 2 to 5 complaints filed against them, totaling of 50 complaints of the 1,081. The majority had 2 complaints. I think we had one person who had 4, one person who had 5. But it seems like a relatively low number for the total amount of complaints that we received.
Thank you very much. Mr. Fu?
Based on those numbers, of the 21 licensees with the 2 to 5 complaints, do we know how many of those had enforcement actions taken upon them?
Some are still
Pending?
pending.
Got
Yes.
understood. Okay. May I follow up with a second, unrelated question but related to the report? So on PM4, the target average is 540 days and the actual average is 929. So what's driving that difference? Because on the other performance measures, we're hitting the targets. So I'm curious, what are the outside external factors that might be influencing that?
Well, PM4, the discipline performance measure, is always a performance measure that is difficult for not only the Board of Psychology, but most boards within the Department of Consumer Affairs. And I believe that the department is considering increasing that number from 542 because of the difficulty it is to meet that number. But there could be several factors that are involved. I mean, if one case takes too long, it will affect our total overall processing time. So sometimes you may have writs that are involved that's going to prolong a case. But these are cases that the Attorney General's office is working for us. So there are outside factors that are outside of the board's control. But again, that has constantly been a struggle for us and for other boards within department. What typically happens with the performance measures when they are issued and they're issued on the department's website, you can actually go and look at each board. And again, it's a struggle for most. You're welcome.
So, you know, because we've heard this complaint before, how long something, you know, stays, and we see that we're definitely in our time frame, then it
Correct.
goes out of our control. And it's out of our control, but we hear the complaints.
Right.
So I'm wondering about that. I mean, are boards getting together? Are new people being hired? I mean, what kinds of things are happening to address the things that are out of our control?
Well, I don't know if boards are getting together, but I know on our part, board staff sends emails asking for status updates. My staff is currently tracking each and every one of their cases that gets sent, whether it's investigations or the Attorney General's office. So we're asking for constant status updates on our cases. But I would imagine that it's possible that some of the field offices with the Attorney General's office have been short-staffed from time to time, so that is going to affect the numbers.
Are we sending out, I'm sorry, I didn't.
Sure, no, go ahead.
But I want to make sure that we're doing what we can to let people know. So then when you get a status update, do we send a status update out to the complainant or, you know, people who are involved in this? Here's where your case is. Here, you know,
We
here's
don't
what you-
send a status update. With over 1,000 complaints, that would be difficult for us to do. However, if a complainant were to call our office and ask specifically about their case, we would then give them an update. But in our complaint form, it does break down the timeframes, that this is unfortunately a lengthy process. We understand that, but again, we're not able to send out status updates every 30, 60 days to every
Okay.
complainant.
So then is it clear on the materials for complainants? You can call our office anytime and we'll be glad to give you a status update or contact us anytime so that it's really clear, even if we're not sending out those updates, because, you know, that
Right.
they can always contact us.
I'm happy to double check the complaint form when I get back to the office, but I'm sure that it is clear in the form. We get calls constantly from complainants and licensees asking for status updates, and I know that my staff does provide that information.
Okay. I mean, that's great. You know, I'm just hearing this, so I don't know where a breakdown might be.
Sure,
So,
sure, no,
yeah.
absolutely.
Thanks.
Ms. Monterrubio, did you want to address your meetings with the Attorney General's office? Don't you meet with Mr. Castro?
We do. Antoinette and I meet with Gloria quarterly throughout the year, just about board concerns or even updates that are happening with the Attorney General's office. So Gloria does meet with us in Antoinette's office. Those meetings have been, in my opinion, very successful. I feel like we have a very good relationship with the Attorney General's office. As you all know, Joshua Tomplay is our DAG liaison. So even when we are having cases that may take too long or we're not getting the response that we need, we do turn to our DAG liaison, and Joshua has been incredibly helpful with that process.
I'd like to make a quick comment on how we sort of language the idea of giving status updates, and particularly to complainants who I clearly understand have a stake in the resolution and the outcome, but I believe that once a complaint is filed with the board, it's really the board's complaint. Only in very few cases is there an outcome that directly impacts the complainant with respect to, you know, maybe some restitution. Clearly they have a stake in it, but the prosecution of the case is really on behalf of the executive officer, and not with respect to an individual complainant. And I think that the staff would probably not want to go to a system of keeping individual complainants update. To be really clear that the board is doing their work in the name of the executive officer and not in the name of a particular complainant.
So that's extremely helpful. And even that kind of process, I think, is important for people to understand. We don't want anybody not to have his or her due process rights. I mean, that's not what this is about. But I am wondering if some education might be helpful. You know, here's what we do, here's what happens once a complaint comes into us, you know, sort of like I think it's going to be happening now, but in some kind of way to let people know this is what this means, you know, because you take action really on behalf of the people of California. I mean, not, right? I mean, essentially.
And many complainants would actually be witnesses in matters. So clearly there's a stake in there and a very high interest. I just want to be clear that the board is doing it in the name of the executive officer and not in the name of a complainant.
And the process is explained in the complaint form. I mean, it does provide a breakdown of how long everything takes, and they're assigned an analyst that they can contact with questions. So that is currently happening.
I think that's great. So again, I'm just hearing, what we're all hearing is like, well, where are these breakdowns occurring then? That's all I'm saying. Thanks.
And as you recall, we did change investigative units because their HQIU was having such staff shortages. And now we're currently working with the Division of Investigation, and we have our own internal special investigator as well. So when we see breakdowns, we are looking to see what we can do to expedite the process for the consumers. And I think working with Division of Investigation has been a huge increase in our investigative numbers.
And Ms. Marks, I guess, and I thank you so much for giving that perspective. And then I'm with you, Dr. Horn, too. I feel like in terms of not necessarily just being reactionary to one or two conversations about not understanding or not getting the responses. I'm just thinking also about, it's kind of further in the agenda about streamlining work and electronic kind of being able to be a smarter, more efficient, but also ensuring that we're doing customer service. Because I feel like, do people just feel like if they make a complaint and it's in a dark hole and they don't know what's going on? And some of it they won't know because that's just the nature of it. But how do we as a board then maintain this transparent perspective as well as a perspective of compassion and service? So I don't know. I mean, I think that we don't do a letter status update, but I think it's a great question to raise because I think that is and to tell people to call the office. I know staff members are super busy. They're going to get a voicemail. So if you had everyone that called everybody, I don't know if staff could actually accommodate that either. And that's what I think about this whole process of looking at streamlining and electronic. So in any case, I don't have a proposal to recommend, but I feel like it's an important conversation to continue because I do think that you're right. We hear this and we hear maybe only a tiny fraction of them, but when we hear them, it gives me pause to say, well, what could we do better? When I know staff is already doing great work.
Sure, and I think calls get escalated to me as the manager of enforcement, and typically those calls are because a consumer is not happy with the fact that we closed the case. But I don't get calls saying, I can't get a hold of your staff. No one's returning my phone calls. Because then I would speak with Antoinette and we would figure out a way how to make sure that we are providing good customer service because a consumer wants to know what is happening with their complaint. And they may get a voicemail when they initially call, but they will get a return phone call within 24 to 48 hours. That is our board policy. And that is happening. So again, calls get escalated to me because they're not happy with the closure. And I'm happy to take those calls and explain why that's happened. But I'm not getting calls that they're not getting return phone calls.
And then,
That's great.
didn't we also bring up at our last board meeting that we were going to see copies of the letters that people received?
I was just going to mention that. One of the things that the enforcement committee will be discussing is some of the letters that the template for the letters that we send out to complainants. And that's something the enforcement committee will discuss. I was going to propose maybe at the November or the February meeting, once the enforcement committee is able to review the letters, perhaps providing a copy of what our complaint form looks like and what our initial response letter looks like to the board so that you all can see what is being sent out to complainants. If that would be helpful, so that you guys know what kind of communication we're sending out and what kind of process we're relaying to complainants.
And you are right, we did discuss it at our last meeting. In fact, after our last meeting, we met with the chair of enforcement. Lucille met us in our office, and we put that on our agenda for the enforcement committee to look at some sample letters. So we'll be doing that in October and hopefully bringing that to the board in November.
We have not had an enforcement committee meeting since the last board meeting, so we haven't had an opportunity to address it as a committee. I also wanted to follow up on this question about the performance measure, the length of time that it takes. In looking at the bar graph here, it appears that the delay is not happening in our office.
Correct.
The delay is happening in investigation and in the prosecution.
Correct.
And we are doing as much as possible to address that.
Yes. What we have control over is sending those cases out to investigations or the AG's office as quickly as we can, and we are doing that. Again, sometimes our investigative units have staff shortages that they're dealing with, which we have to understand, and they prioritize the cases once they're received. They are not just working for the Board of Psychology. They're working for a good majority of the boards within the department. So once they get the complaints, they prioritize how they're going to work these specific complaints.
And with the shift in units, given the staff shortages in our investigative unit that we had used for all of our cases, it seems that we're getting more expeditious and rapid response.
Absolutely. So far, we've been very happy with the Division of Investigation. We just signed a new MOU with them that went into effect July 1st. So we're doing another year, and hopefully things will go just as smoothly as they did last year. So we're looking forward to continue to work with them.
I mean, I'd just like to say, I think y'all are doing a great job. I know it's a really hard unit for a lot of reasons. You know, you end up with a lot of unhappy folks through no fault of your own. What I really appreciate is particularly is how you really, and I've seen you and now talk to groups of psychologists and stuff, you know, how much you really take in, and it's important for your whole unit to, you know, you really deal with people very respectfully. I mean, all across the board, the people who, the psychologists who have been accused of, or complaints are filed against, and the public too, you know, the non-psychologist public. So this is not about at all that you're not doing a good job, but really just kind of, you know, what you said, Ms. Jones, it really is about how can we do a little better to solve these breakdowns. And I think just, again, this more education, you know, hearing, just have it somewhere out there, you know, and it might be on the complaint form even, that we're not the only group that the investigators are working for, you know. They're looking at all the boards and, you know, working for all the boards or whatever. That's really helpful, you know.
Right. And that goes for the Attorney General's office as well. So, no, I appreciate your words, and I think looking at the complaint form will be great for everyone. But again, it is posted on our website right now for you to view, and if you have any comments or changes, you can always email me, and I'm happy to discuss those changes with Antoinette.
Mr. Fu?
Returning back to the multiple complaints per licensee, if that licensee complaint is closed out and then there is another complaint filed or multiple complaints filed again, is there more than one peer reviewer than the professional review? So you mentioned there's 40 out of 40 currently, and you want to seek to 100, but if there's multiple complaints against one licensee over a period of time, is there more than one professional review, quote unquote, of that case the next time it comes up around, or is it still one?
We try not to send it to the same expert that reviewed the last case. In fact, we even try to not assign it to the same analyst.
Okay. Great.
So we have different people working these complaints.
Great, thank you.
Absolutely.
And I just want to say ditto what Dr. Horn said, and I always get my phone calls returned. I was just thinking about the number of calls, so I definitely want to say that I appreciate all the enforcement staff and keeping us in line and responding to them too. So just wanted to make sure for the record that was stated.
Sure, thank you.
Was there other information you wanted to impart to us relative to the enforcement report?
No, I think that's all I have.
Okay.
May I just thank you very much, Ms. Monterubio. Well done.
Thank you.
Okay. Is there any public comment on the enforcement report? And we're going to try to hold, consistent with your suggestion, we'll try to hold each public comment to a maximum of 5 minutes.
Thank you. Catherine Campbell.
There it is.
Catherine Campbell. Now you all know 3 times. All right, so the light's on. There we go. Is that better? I want to thank the board for taking time with this, for Ms. Monterubio reviewing the questions that we asked last time. I didn't see it in her pre-analysis, so I'm glad she shared that with us today. I'm back again because I realize that there's a procedure in place. And I think the procedure has been reviewed in our meeting in February in Ontario. I'm seeing how we're seeing data. We're understanding when it goes to the AG's office, how much longer it takes. I think it was brought up earlier in public comment that these children are in situations during that time where they could be being molested the whole time. The whole time the AG is looking at this for 2.5 years. And more children could be being added to that list from one perpetrator that the evaluator chose not to look at. These are very, very important situations. I mean, a child, if they're abused once, it stays with them their entire life. Multiple abuse to a child is devastating. These are very important issues, and I understand there's this procedure, but what I'm concerned about is that abuse is being invalidated, even within the procedure. I do have a question, and it is, first off, I'm concerned that I'm not seeing on the list of who we want to be these experts that they have any trauma-informed education. Trauma-informed education is what's needed. And if they don't have that, they're not going to be able to see this in the viewpoint to understand about the abuse. The transparency that is coming across, I certainly know that I brought forth multiple cases to you last time, and I hope that got distributed in a redacted form. And did that get distributed to everyone? It could be. Okay, great. So there's been no resolve in any of those cases that I've heard of. And maybe I didn't hear about all of them, but that was from February. They were all about one person. And that means that one person is still seeing multiple people since these complaints were filed and then reopened. The concerns are quite large. And so the procedures are happening. I don't know where the disconnect is. There's the disconnect of actually having someone admit that this abuse is happening. It's very clear that it's happening and these cases are being closed. There's a procedure for people to look at it. Where is the breakdown? I don't know, because I know everyone here wants what's best. We've seen the Catholic Church go through this. The blind eyes happen, and that's what needs to end. I want to make sure I did have a question on her numbers. So when, I have a question. If a person has a complaint against them, are they allowed to be added as a reviewer? So if there's ever been a complaint against this person, can they be hired as a reviewer?
Yes, they could. It depends on when that complaint was filed and the disposition of that case. As I think we all understand that anyone, for any reason, can file a complaint against a licensee. We've had disgruntled employees, we've had ex-spouses. I don't think that it would be fair to preclude those individuals from our program if they're qualified and they meet the criteria. So we look at every single application that comes in, and we look to see whether or not they have any type of enforcement history. So
Right.
it's on a case-by-case basis.
So that brings to the point that you have reopened a case for someone because there's very valid complaints. So even though this complaint was originally dismissed, it was reopened, which says to the fact that that person, prior to it being reopened, could actually apply for this position. And that's very concerning to me. And I understand that, for instance, with child sexual abuse, we know that people who have the children, and it's 5 minutes, but did you count Ms. Monterrubio's comments? Yeah, I just want you to realize that usually there's less invalid complaints than valid complaints that we've seen and all the surveys that we've looked at. So we need to be very concerned about what's happening, and I will close by just saying we need to stop dismissing abuse, even though we have a procedure. Thank you.
Thank you very much. Any additional public comment?
Hello again, Kathleen Russell, Center for Judicial Excellence. I wanted to raise something with the board. In viewing the video of the last meeting, saw that quite a number of the board's requests were referred to a enforcement committee meeting or the next enforcement committee meeting. But when I went to your website to look for those enforcement committee meetings, there was no mention of them on your page dealing with board and committee meetings. There were other committees that were scheduled to meet, but there was none related to the enforcement committee. So I just would ask, is this a private committee, or is this open to the public in the Brown Act, or does this committee just not meet on a regular basis? But I know that Antoinette just referred to bringing something to the enforcement committee and then having the result of that, the particular letters that are sent to complainants, that would be brought up at the November or the February board meeting. So can someone please explain why that enforcement committee meeting isn't anywhere to be found on your site? Are those closed to the public?
I believe that the enforcement committee is made up of only 2 people and therefore is not subject to the Bagley-Keene Open Meeting Act, yes.
So those are closed private meetings?
They are not open, yes.
Uh-huh, okay. And that 2-person committee is not by rule or statute, it's just currently the way it is?
Correct, by statute. The statute defines a body as 3 or more people.
Okay, right. But this board would be open to adding a 3rd person, and that would then make this a public committee? Seems like a pretty important committee, so.
That would be up to the board.
Okay. Also, there was a lot of mention in the last discussion on the child custody complaints about what you refer to as subject matter experts, or they were referred to as SMEs. And I just want to clarify, since you are doing this big push, which I think is wonderful, to get more than double the size of your expert reviewer program, is that who you're referring to here, are subject matter experts that you're recruiting and that will be trained in November? Or is that a different title?
Well, we call them expert reviewers. They can be called SMEs as well, but that is what we'll have the training for in November.
Right, so, okay, those are the subject matter experts. And the reason I raise these is they seem to have a tremendous amount of power in the complaint process of this board. And I share my colleague Catherine's concerns that there is a lack of transparency in terms of who these people are. The reason that we are concerned, I mean, they appear to serve a triage role for this board, so this board actually isn't hearing complaints based on the subject matter experts can simply close these cases. And so these are very similar issues that have been brought up in a similar audit with the Commission on Judicial Performance, which our organization pushed through, and the legislature unanimously agreed in the JLAC committee to audit the Commission on Judicial Performance because there was a lack of transparency, a lot of confusion about what is happening to complaints. They seem to go into a black hole and never come out. And there are very low rates of discipline at the CJP, similar to the low rates of discipline of this body. So I guess I'm just wanting this body to consider what you can do to create more transparency. And I understand if you're not able to identify who the expert reviewers are, for instance, that are looking at these child custody complaints. But the reason the public doesn't trust a lack of transparency around these important decision makers in your system is that there is a lot of corruption in these particular people that you may be recruiting as subject matter experts over the next month. Many of them have questionable beliefs around junk science. They have forensic credentials that have been identified to be part of online diploma mills, where someone actually submitted a request for an application for one of the main custody evaluators in the state who's worked on hundreds, if not thousands, of cases, who might be just the kind of person that you're using to triage these complaints. And this pet cat for $350 got a forensic psychology credential, and this was all exposed in the news media. So we obviously have concerns, and we'd like to work with this board. I see that my time is about up, to figure out a way to be more transparent without having to go through a JLAC, but we're prepared to do that, to get a sponsor in the legislature to audit this board if we can't come up with more transparency. Thank you.
Thank you very much.
And if I could just clarify one thing, our experts don't close our cases. Our experts opine as to whether or not there's been a departure from the standard of care. Board staff decides whether or not a case will be closed.
Thank you for your report, Ms. Monterrubio.
You're welcome.
Very much appreciated. Now going to take a break. Did you have some additional? Okay. Go ahead.
Real quickly for clarification, if they have a prior or current charge for or formal disciplinary action, they cannot be an expert. Is that correct?
That is correct.
Great. And then, as you mentioned, just to restate that, if they have multiple complaints, it's sent to more than one. It's sent to a separate analyst. Is that correct?
Yes.
And it's sent to a separate subject review or a subject expert or review expert.
Yes.
Great. Thank you.
And I'm so sorry. I know we all need a bathroom break. I have a little bit of hesitancy and a little bit of concern. This came up about a year ago with the telepsychology committee. I am concerned about the fact that we would have a committee, and I know that I understand the Bagley Clean Act very well and have done my ethics training. I think just like we talked about this with telepsychology, given the nature and the importance of the issue, I think it would be a departure from our perspective and our goals and our kind of values as a board to not be transparent. And so I don't know what format we would discuss this, but I was never under the impression that an enforcement committee meeting would not be noticed and would not be like a licensing committee meeting or a policy and advocacy committee. So I have a lot of concern about that, and I think that we should discuss it. I know this is probably a bigger issue before a break, but I definitely feel like that is something super important that I don't think it should just be closed to the public.
Thank you very much. We'll now take a 10-minute break.